on this episode of Law Weekly, highlights from the just concluded National Summit on Justice 2024, jointly organized by the Federal Ministry of Justice, the National Judicial Council NJC, and the Nigerian Bar Association. Also showing on the program, former president of the Nigerian Bar Association assesses the performance of the federal government almost 1 year after assuming office. Plus our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shoyeli. President Bola Tinubu has asked the judicial arm of government to seek new directions and embark on reforms that will ensure a functional justice system, support a rapidly growing economy, guarantee human rights, and one that will respond to the needs of all Nigerians. The president made these comments at the National Summit on Justice 2024, which had the theme Repositioning the Justice System, Constitutional, Statutory and Operational Reforms for Access and Efficiency. Vice President Katim Shettima, who represented the president, led the executive to this event, which also had the Senate President, Senator Govt, leading the legislature, and the Chief Justice of Nigeria, Justice Olukayode Ariwola, leading the judiciary. It held at the National Judicial Institute in Abuja from April 24th to the 25th. The Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Prince Lateef Fagbemi, in his welcome address, says the idea of a National Summit on Justice was conceived in 2017 to provide a platform for critically analyzing, discussing, reviewing, assessing, and resolving issues affecting the administration of justice in the country. He recalled that justice sector summits were held in 2017 and 2022, and this particular summit, he says, offers an opportunity to assess the successes recorded and challenges faced since the last summits. It also provides a platform to measure the impact of the reforms initiated by the 2017 to 2023 National Policy on Justice and scrutinize in more detail the revised 2024 to 2028 National Policy on Justice.
A major objective of this summit is to validate and adopt the revised National Policy on Justice 2024-2028, which is a product of extensive research work and consultation undertaken by critical stakeholders in the justice sector. It provides a comprehensive assessment, review, and consideration of issues militating against the effective administration of justice, as well as a well-articulated broad roadmap of initiatives, actions, and responsibilities for addressing and repositioning the justice sector to effectively and efficiently discharge its duties in enhancing national security, upholding the rule of law, promoting the protection of human rights, democratic principles, and socio-economic development of our dear nation. I invite all participants to note that the draft policy itself is an ambitious document which aims to serve as a catalyst for the transformation of the entire justice sector in Nigeria. Permit me to highlight some of the key interventions proposed to be pursued in the revised National Policy on Justice 2024-2028. First, the policy seeks to promote and protect human rights and access to justice, which are essential features of a functional justice system. It proposes critical and sustainable interventions in the implementation of statutory provisions, encouraging protection of human rights and access to justice. The policy also seeks to improve mechanisms for fair and speedy dispensation of justice, detention and correctional services, restorative justice, alternative dispute resolution, ADR, developing Nigeria into an arbitration hub on the continent. One key theme that has been added to the policy on justice is justice for children. This is in line with our commitments under various international, regional, and national instruments on protection of children, consistent with the guiding principles on the best interest and welfare of the child. The justice sector, under my watch, will continue to push for mutuality in the formulation and implementation of national policy on justice and national judicial policy. In furtherance of the above, we are developing draft constitution amendment bills which are aimed at achieving the aims of improved access to justice, deepening the independence and capacity of the judiciary, and eliminating delays in the administration of justice, among others.
In his opening remarks, the president of the Nigerian Bar Association, Senior Advocate of Nigeria, Yakubu Mekiao, says collaboration is necessary for the change and reforms ahead.
One of the core approach or modalities that we've adopted in the NBA of making sure that we turn things around in the areas that we are called to provide leadership and direction in the country and also advance the cause of the nation is to engage with all the stakeholders. Gone are the days when we would go out and begin to spew words, derogatory words, against any sector of the polity, just because we want change to happen. We've done that over the years, and we have seen that nothing came out of that. And the best way to do it is engage, show respect, make your points known, and together we can work to transform this country and bring this country to that place where all of us dearly yearn to see, dearly yearn to have an experience in this country. Yes, we may not be where we ought to be in terms of what we expect of the judiciary and the efficiency and the effectiveness of the judiciary. But something very comforting happened to me in March this year when I had the opportunity to travel to Canada, and I had the privilege of witnessing the hearings of the Supreme Court of Canada on the 26th and the 27th of March. Not only that, I had a session with the registrar of the court, the registrar of the Supreme Court. There I discovered that even though that court will be 150 years next year, 150 years, we'll be celebrating its 150 years of existence next year. It was not until 2022 that they developed a formal documented process of appointment to their courts. So when we draw comparisons with countries and try to compare what happens there with what we have here, we play down what obtains there in order to vilify our system. And I dare say that without the judiciary, this country would have been torn apart a long time ago. The statements that have come from the bench of this, of the judiciary, of the courts of this nation, have been largely responsible for keeping this country together. The position of the judiciary is no less the position of any of the security agencies. Because if you do not deliberately invest in the judiciary, then you are ignoring the very fabric, the very foundation on which this country stands. That is why we've consistently called on government to make deliberate investment in the judiciary, because there lies the existence of this country.
The Chief Justice of Nigeria agrees with the NBA president. While noting that reforms in the judiciary are necessary, he wants governments to do more in the areas of funding the justice sector.
Access to justice remains a distant reality for far too many Nigerians, with barriers ranging from procedural complexities to socioeconomic disparities. The quest for justice should not be a privilege reserved for the few, but a right accessible to all, regardless of their circumstances. Therefore, it is incumbent upon us to embark on a journey of comprehensive reform to ensure that justice is not only dispensed, but also perceived to be dispensed fairly and impartially. Constitutional, statutory, and operational reforms are imperative if we are to reposition the justice sector for the 21st century. We must critically examine our legal framework, identifying gaps and inconsistencies that hinder the efficient administration of justice. Moreover, we must be bold in our pursuit of legislative reforms that reflect the evolving needs of our society, while upholding the principles of fairness, equality, and human rights. We must leverage technology and innovation to streamline court processes, reduce delays, and improve the overall efficiency of our judicial system. By embracing digital solutions, we can enhance transparency, accountability, and public trust in the administration of justice. Furthermore, we must address systemic issues that undermine the integrity of our justice system, including corruption, inefficiency, and undue influence. Upholding the independence and impartiality of the judiciary is paramount, as it is the cornerstone of a functioning democracy and the guarantor of the rule of law. At this juncture, let me leverage the privilege of my chairmanship of this auspicious occasion to succinctly report to the distinguished assemblage of eminent personalities at this summit that under my watch, the Nigerian judiciary has recorded significant milestones consistent with the theme of the summit. Most of us are aware of this. While appreciating the President for his unflinching support to the sector, it is worth stating that financial resourcing remains a major challenge for all justice sector institutions. I charge this summit to explore innovative ways through which to address the systemic challenges of funding the entire justice sector in a sustainable manner at all levels of governance, horizontally and vertically.
The Senate President pointed out specific reforms that are needed in the justice sector, while seeking the support of all stakeholders to ensure that the major reforms are achieved.
The journey requires collective effort. So I call upon all stakeholders here today, including my colleagues in both chambers, and including the executive branches, as well as the states, particularly with the presence of the chairman of the Governors Forum, because if the states do not concur, we cannot have any major reform in the Constitution. I call on all of you to support these vital reforms, because I believe together we can build a system, a justice system that is fit for the 21st century. It is essential that we reform our approach to interlocutory appeals in our civil cases. Currently, these appeals often cause unnecessary delays, prolonging litigation and burdening our courts, as was done in the criminal jurisprudence during the enactment of Administration of Criminal Justice Act 2015. We propose that all appeals in civil cases should be taken only after the conclusion of the substantive matters. This change will accelerate judicial processes, reduce backlog, and ensure that litigations are not unduly prolonged by intermediate appeals or intermittent appeals. You know, sometimes the interlocutory will take maybe 9 or 11 years, and then by the time we come to the main cases, the litigants have died. Another area requiring urgent reform is the need for obtaining the Attorney General's consent before executing judgment. Why do we need to obtain the Attorney General's consent when the Supreme Court has spoken? And it should be after the Supreme Court, it should be God. Are we saying that the Attorney General is not God?
The executive charged the participants here to embark on bold reforms that will support the economy and ensure a functional justice system that responds to the needs of Nigerians now and in the future.
There's an urgent need for a functional justice system capable of supporting a rapidly growing economy, guaranteeing basic human and political rights of individuals, and providing security and justice to all. This makes continuing reforms imperative. It further underlines the need for the establishment of reliable metrics and benchmarks across all justice sector institutions, in order to identify needed system changes and evaluate the effects of reform measures. Justice sector leaders and professionals need to find the right responses to the challenges we face through policy innovation, citizen-centered reform, system change, and legislative reform where necessary. I accordingly urge the leadership of all justice sector institutions to seek a new direction and focus on outcomes by creating a justice system that fully responds to the needs of our citizens, one that serves Nigerians now and for generations to come. The impact of your reform efforts should be visible in terms of improved access to justice, strengthened integrity of justice sector institutions, increased timeliness and quality of justice delivery, accountability and transparency of the system, and ultimately improve public trust and confidence in the judicial system.
Thanks for staying tuned. Former president of the Nigerian Bar Association, Olisa Agbakoba, has been assessing the performance of the federal government almost 1 year after assuming office. He says the president needs to pick up more speed to alleviate the sufferings of the majority of the populace.
So if you ask me, President Tinubu's policy statement was refreshing because it was different from President Buhari. And President Tinubu's policy statement was almost akin to what Peter Obi said and what Atiku said. We have to protect our markets. Period. We have to protect our markets. We can't be a dumping ground for everybody. So Nigeria is a borderless country where everybody comes and dumps. So Peter Obi's punchline, from consumption to production, is the perfect, policy solution. If that from consumption to production were to hold firm in all the sectors, you will see the results. The result of Dangote just pumping meant it was from production to from consumption to production. Before we were consuming imports. But I said we can do it locally. Local tomatoes, local onions, local yams, local rice, local everything, local hospitals. The prices will go down. But not to sit in Abuja and keep making policy statements without backing it. Onyema has shown from consumption to producing services will drop. So the answer is simple. If there was an articulated national economic policy that says Nigeria first, and government really would mean it, you will see the changes. It will be very obvious in whatever sector that you are thinking of. So in assessing the 1 year in office, I'd say the speed is not as fast as it should be. There's the possibility of telling the pilot, Captain Tinubu, push the throttle back and accelerate so we can get to cruising level quick, because the possibility of a return, it's called an air return, is there. So the pilot will be advised by air traffic control that you no longer can continue climbing, so you need to turn back. So that's where we are. We have not stabilized, and the challenge for President Tinubu, because I like to be positive. If you criticize people, it doesn't help. We all want a good Nigeria. So I'm not going to offer any criticism. I'm going to say, here's what I've seen. You are behind schedule. You're not going to land in Abuja in 1 hour. You're going to land in 1 hour, 30 minutes. But all you need to do is push the throttle and get to Abuja in 1 hour. And that is possible. But you have to look at the entire environment. Are the ministers the right people to be in office? Are the right issues being addressed? Why is government still in business? Why should government not devolve business to the private sector? Do you know if Mr. President were to take that decision to say, henceforth, the government is not going to be in any business, you will see the massive opportunity that will open. So that's the way I'll answer it. So it's not totally fallen. I know that Nigerians are absolutely, going through pain, but that is the pain that is required if you want to turn around. But there's still a very big trust deficit. If I ask you to bear pain and then you see I'm not, then there's a problem. So there's a trust deficit that the president needs to close in.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Federal High Court sitting in Abuja has fixed May the 10th to rule on an application by former Governor of Kogi State Yahaya Bello seeking an order to set aside the arrest warrant issued on him. Following his absence in court, Justice Emeka Nwite ordered the Economic and Financial Crimes Commission to serve him a copy of the charge through his lawyer Abdul Wahab Mohammed. This was done in open court. Meanwhile, the EFCC has filed a notice of withdrawal to discontinue an appeal against an order of the Kogi State High Court restraining it from arresting the immediate past governor of Kogi State, Yahaya Bello. In the notice filed on April the 22nd, the EFCC said the withdrawal is predicated on the fact that events have overtaken the appeal. The Commission also admits that the appeal was filed out of time as allowed by law. In another case, the EFCC is set to arraign the former governor of the Central Bank of Nigeria, Godwin Emefiele, for approving the printing of 684.5 million naira at the rate of 18.96 billion naira. In the fresh 4-count charge filed against him, the EFCC alleged that the Emefiele disobeyed the direction of law with intent to cause injury to the public during his implementation of the naira swap policy of the administration of former President Muhammadu Buhari. The anti-graft agency also accused Emefiele of unlawfully approving the withdrawal of 124.8 billion naira from the Consolidated Revenue Fund of the Federation. The former CBN governor will be arraigned on these counts before Justice Marian Aneni of the FCT High Court Abuja on April the 30th. This arraignment will bring to 3 the number of charges pending against the former CBN governor. Still in Abuja, another federal high court has ordered the arrest of the former Director General of the National Institute for Legislative and Democratic Studies, Professor Ladi Aisha Hamalai, for her failure to appear in the corruption case preferred against her by the Independent Corrupt Practices and Other Related Offences Commission, ICPC. Trial Judge Justice Christopher Oba issued the bench warrant on Monday, April the 22nd, for the arrest of the professor following her repeated failure to show up in the court. The ICPC counsel, Michael Adeshola, had informed the court that this is the 4th consecutive time that the former DG of NILS failed to honor the invitation of the commission to appear in the case having been properly served. In the suit, the ICPC is accusing Professor Hamalai of using her office to confer corrupt advantage upon herself by making a request for the sum of 12 million naira to rent a guest house for her office, but used the amount to purchase a property for herself at Gwarinpa area of Abuja. In Kano, the State High Court, presided over by Justice Usman Nahaba, has vacated the order suspending Mr. Abdullahi Ganduje as the National Chairman of the All Progressives Congress. Justice Nahaba, while vacating his earlier order, says upon reading the motion ex parte together with the affidavit in support, it was necessary to reverse the earlier order suspending the National Chairman of the All Progressives Congress. The judge adjourned hearing of the substantive case till April the 30th, 2024. In Lagos, the Federal High Court has freed the former Director General of the Nigerian Maritime Administration and Safety Agency, NIMASA, Patrick Akpobolo-Kemi, over an alleged 8.5 billion naira fraud brought against him by the EFCC, the Economic and Financial Crimes Commission. Justice Ayokunle Faji acquitted and discharged the former NIMASA Director General while ruling on a no-case submission filed by him and one other defendant, a staff of NIMASA, Josephine Otuaga, in the 22-count charge made against them. Justice Faji held that the EFCC failed to establish a prima facie case against them. The court also ruled that the former commander of the Joint Task Force, Operation Pulo Shield, Major General Emmanuel Atere, retired, who is the second defendant, and the staff of NIMASA, Kime Ngonzu, who is the third defendant, have to open their defense as they have a case to answer, especially with regards to counts 12 to 22 of the charge. And we round up with a report that the controversial cross-dresser and socialite Idris Olanrewaju Okuneye, popularly known as Bobrisky, has filed a notice of appeal challenging his sentence on a 4-count charge of naira abuse. In his notice of appeal, Bobrisky is asking the court to set aside the 6-month imprisonment sentence imposed on him and replace same with the option of a fine of 50,000 naira of each of the counts against him. On April the 12th, Justice Abimbola Awogboro of the Federal High Court Lagos had sentenced Bobrisky to 6 months imprisonment without an option of fine for abusing the Nigerian currency, the naira, following a guilty plea by the defendant. The judge, while sentencing the convict, said the judgment will serve as a deterrent to others that are fond of abusing and mutilating the naira.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shiele. Thank you for watching and see you next time.